Yeah, thanks so much for that gracious introduction. And maybe Nick, you're going to be my person. So just as a warning, my internet service provider has been doing weird stuff today. So I try and have a couple of connections, but someone needs to kind of move around in the background so that if I lose my connection, I can figure that out and we won't drop. Thanks. So thanks, Andy and SMU, for hosting this. I'm really looking forward to this conversation. I see a bunch of names of people who I know and greatly admire. I'm going to talk today briefly about three different research projects that I've done over the years in this area and just talk about some of the results. They're organized in this theme of how can indigent defense help shrink the impact of the criminal justice system. You'll see that there's some, I think, common methodological threads. Hopefully you'll find the results interesting. I'll also talk at the end very briefly about what I think some maybe larger insights for indigent defense policy are from this body of research, and also maybe what we can learn about the indigent defense research as well. And I'm looking forward to your questions and comments. As Andy said, I kind of got into this world through the intervention of my co-author, James Anderson, who previous to becoming a researcher, worked at the federal defender doing habeas appeals. And so kind of my first foray was a paper that we published almost 10 years ago now that was focused on this question of how does the performance of public defenders compare to private appointed counsel in high stakes, complicated cases? As you know, for those who do research in this area, one of the challenges in trying to understand what the effects of particular indigent defense organization practices are is, it's often not the case that we're going to have multiple systems operating in the same environment. Maybe we have a public defender, maybe we don't have a public defender and we just use private appointed attorneys. In situations where we do have kind of both of those systems, probably the set of clients that are going to the private appointed attorneys are fairly different from the public defenders. And so this creates a challenge if we want to measure the effects of one particular approach to providing indigent defense. How do we figure out what the difference between the impact of that approach is versus the characteristics of the clients? And so all of the studies I'll talk about are studies that are designed to try and figure out ways that we can actually make causal statements about how we provide indigent defense. And to do that well, what we want to do is do something like we would do in, say, a clinical trial for a vaccine, where we identify groups of people who otherwise are similar, we think, in their characteristics, but we give one, a group the vaccine and one group the placebo. Here we want to find situations that are naturally occurring in the world, or perhaps create them through our research, where we have similar pools of defendants, but they get different types of indigent defense for reasons unrelated to the quality of their cases. So in this first study, right, we looked at Philadelphia, and this came from James's practice experience, where he noticed that one of the things that happened is due to a contractual arrangement with our public defender, the Defender Association of Philadelphia, 1 in 5 homicide cases were handled by them, and the remainder went to private appointed counsel. And Philadelphia had an assignment wheel, right? So every 5th case that came up, through the preliminary arraignment, we'd go send to the public defender, and then the next 4 would go to private appointed attorneys. And this seemed to us to provide a good opportunity to be able to really figure out what the impact of having the public defender was in this scenario. And so we actually web scraped, kind of full criminal histories and information about 3,000 murder defendants, as you can see on the slide, over about a 12-year period. And in this project, and in the other 2 I'll describe, there's kind of a combination of an econometric analysis that tries to measure the effects, in this case, of having a public defender. And so we kind of do that using a large administrative data set. And then we also supplemented that with lots of interviews with people who are on the ground, public defenders, private appointed attorneys, judges, and other folks to try and understand a little bit better from a qualitative perspective what was going on with our results. So I'm going to show you a bunch of slides, and I just want to point out that, again, this research design is designed to measure, and what you'll see when we kind of compare different bar graphs is, what we're measuring here is if we were to have, a pool of clients and they were to all have private appointed attorneys, and then we were to take that same pool of clients, so accounting for contextual factors, and then give them public defenders, what would be the difference in outcomes? And so, there's a lot of statistical machinery that we try and use to make those causal statements that I won't go through here, but that's the idea. And, among, kind of statisticians, these sort of research designs that are based upon, randomization or quasi-randomization are kind of viewed as the gold standard in terms of quality of, statistical evidence. So in this particular study, we found that public defenders matter quite a bit. If we look at overall conviction rates, not huge differences, and certainly not statistically significant ones. But if we looked at the most serious potential outcomes from the perspective of the client, were you convicted of murder as opposed to some lesser charge, for example, we saw a pretty large disparity, about 10 percentage points less likely if you have a public defender. If we look at kind of the actual sentence that you receive, huge differences in life probability of a life sentence, which here in Pennsylvania is without parole. So about 1 in 4 clients of private appointed attorneys, if we were to give those folks public defenders, our estimates is that the fraction that would have life sentences would go down to 1 in 10, so an almost 2/3 reduction. If we look at the actual length of the sentence, on average, this population facing sentences of about 20 years, that goes down by about a bit more than 6 years if you have the public defender. So pretty substantial differences. And so one of the takeaways from this study is that, our method for providing indigent defense matters quite a bit. Of course, we might think, well, what is it that was different? Why did the public defenders in this setting perform better? And we point to, and from our interviews, we identify a variety of different factors. First of all, the Defender Association would actually assign pairs of attorneys to staff these cases, and the private appointed counsel were working in isolation. And so we think that team approach helped to be more realistic, identify weaknesses in the cases. The public defenders and the Defender Association had better access to experts. They didn't have to petition the court and get kind of money and resources to hire experts. They had a more systematic system of training. And as you can imagine, with these complicated cases, training and experience potentially very important. And there were some features of how private appointed attorneys were assigned, the fact that they had to get kind of a judge assignments, and also the compensation system, very low compensation for these capital cases at the time we wrote the study, and those created some conflicts. Fortunately, as a result of effort by some people here, and I think at least in small part is in response to the research, there were a number of changes instituted. They quadrupled the pay for private appointed attorneys. They started assigning them in pairs to handle these cases, so some improvements. And I think that's probably a good thing, because one of the things we show in the paper is that as a result of these large differences in impacts, our choices about whether to have public defenders or private appointed attorneys in this setting were implicating hundreds of millions of dollars of kind of additional spending in incarceration down the road. And one of the themes that we'll see from this research is that I think often these resource constraints and decisions about resourcing at the front end have pretty significant ramifications further on down the line. So that's study one. And that, I think, establishes that public defenders matter quite a bit in these kind of serious, complicated cases. So the next study I want to talk about is another study that we published a couple of years ago in the Harvard Law Review, one that looks at holistic defense. And this is one where the basic question is, now instead of public versus private appointed attorneys, what if within public defenders, we have this newer model, the holistic model. If we were to compare that to a more traditional model, what implications, what impacts does it have for client outcomes? And again, in order to do this well, first of all, we need a setting where we have both models operating simultaneously. And we'd want to find a situation where, again, otherwise similar clients, ones that have similar case quality, get either holistic defenders or traditional defenders for reasons unrelated to the merits of their cases. And we were able to identify that. This was a project that was done looking at the Bronx defenders operating in the Bronx side by side with the Legal Aid Society, a well-regarded, more traditional defender. I think probably most people here know something about holistic defense, but just for those who might not know, what's the difference, right? It's a more interdisciplinary approach. So the Bronx defenders, as clients come in with criminal cases, they get assigned a criminal defense lawyer, but also other paraprofessional social workers, investigators, civil attorneys. And the philosophy is that, their job is to help to address client challenges and needs that may lead to the criminal case. Is it a drug addiction? Is it unstable housing that's causing you to have contact with the criminal legal system, and or that might be created by the criminal case? So is it possible that there'll be implications in family court for immigration? And if so, we want to help you with that. Now, it turns out that the way in the Bronx that they assign clients is based upon arraignment shifts and courtrooms, and it was an assignment process that changed over time. And so we were able to exploit that and use that through a multi-year process. We got access to some nice administrative data that cover about 600,000 cases over a 15-year period. And so again, we did this kind of statistical quasi-experimental analysis here and supplemented that with a bunch of interviews of defenders, legal aid folks, appointed counsel, judges, prosecutors, etc. So let me talk through a few of the findings. Although before I do that, I guess I should mention one thing, right? This isn't just a question of, hey, if we give more money to public defenders, right? If we hire all these additional experts and social workers and add them on, do we get different outcomes? Here's just some budget information that was contemporaneous of our study comparing the Bronx defenders to another more traditional public defender. And as you can see, right, from the city's perspective, they're actually spending about the same on in fact, exactly the same on a per case basis. But, what's different is we have kind of a different mix of personnel and a different, kind of philosophy underlying the defense approach. So what did we found? Again, here we found holistic representation had some pretty important impacts. It reduces the likelihood that people are detained pre-trial, and there's some modest, albeit statistically significant, increases in release on recognizance. When we actually look at what happens to clients later on, pretty substantial shift in eventual sentences. Overall conviction rates are fairly similar between, kind of people represented using the traditional versus the holistic model, but holistic clients were much less likely to be sentenced to jail. If we look at average sentence lengths, and that includes people with no sentences, they go down from about 40 days to 30 days. So that's about a 25% reduction. So fairly substantial. Now, one thing one might ask, if you're kind of skeptical of indigent defense is, well, okay, yeah, maybe you're reducing incarceration a lot, but is this coming at the cost of future additional contacts with the criminal justice system? Or people, once they get released pre-trial or once they have these shorter sentences, are they more liable to get rearrested? Don't we need to impose this incarceration in order to deter people? And so we were able to look, pretty carefully at this in this study. So we followed people up to 10 years after their original case. Here, you can see the clients of the traditional offenders, how many new arrests they pick up. And, this is a, this is a system that affects people a lot, right? And the typical client is having multiple future arrests. If we compare the trajectory for people with holistic defense, there's no measurable difference, maybe at the end, even potentially a slight reduction there. So, one way you can conceptualize holistic defense is it's kind of a decarceration machine, right? We're going to reduce people going to prison by 25%, but with no indication that that has any, kind of problematic impact on public safety, if you think that arrests are an appropriate measure here. And, I think that's kind of good news, right? Kind of whatever one's perspective is, I think you could probably find fairly wide agreement that incurring all the human and fiscal costs of incarceration, if you're not actually reducing people's involvement in the system, is not a great thing. And it seems like this approach might allow for a reduction in incarceration. If you look at the actual types of cases, interestingly enough, we see particularly large impacts for kind of high volume, arguably less serious offenses, drug offenses, larceny, big reductions in sentence length. And again, one of the mechanisms that we think is operating here is this multidisciplinary approach seems to enable the holistic defenders to be more successful at humanizing their clients before other actors in the court work group in a way that leads to more lenient outcomes. Just to give an idea of, are these magnitudes of these impacts big or small? We kind of conservatively estimate that the Bronx defenders were able to avert over 1 million days of custodial punishment through over the period that we studied. If you, again, very conservatively think about how much it might cost to incarcerate people for that amount of time, those expenditures on incarceration, dwarf the kind of entire budget and operating costs of the Bronx defenders. And of course, they're doing a bunch of stuff besides criminal representation. They're also doing immigration, family. We also do a calculation in the paper saying, hey, what if you were to take this model and if you could replicate it across all criminal defendants in New York City based on our causal estimates, what do we think would happen? There you get about 3,000 fewer custodial sentences. And so, for those of you who've heard of like the close Rikers movement, right? I mean, seems like one might actually be able to get fairly far along that road with an intervention focused on indigent defense. All right, so that's the second study. So I'm going to talk last about a more recent study that was just published last year in the Indiana Law Journal. And so this, we established indigent defense important in serious cases. With holistic defense, we're seeing it across a pretty wide range of clients and cases. What about at the very beginning parts of the process? So the basic question we're looking at in this study is, if we, kind of improve the quality of indigent representation right at the very beginning of the process, how might that affect downstream outcomes? And so this was a study that was done in conjunction with the Defender Association. So in Philadelphia, as in many larger urban jurisdictions, you get arrested, you go to a booking facility. Within usually 24 to 48 hours, you have what we call a preliminary arraignment, which combines a probable cause hearing with an initial bail determination. We do those here via video link. And they actually have a public defender on the video during that time. So better than some jurisdictions, right? At least you have counsel there. But at the point that the hearing occurs, typically public defenders haven't had any interactions with the client, and so they're seeing them for the first time. And so the Defender Association launched a pilot program where they said, well, hey, is there a way that we could engage, kind of earlier on with some of these clients? They called it the Bail Advocates Program. And the way it worked is they actually hired a couple of people, not
Paul, we may need you to switch to your phone. Nick was waving gallantly, if you missed that.
Andy, I realized the problem with the waving was that it didn't really have, I mean, like Nick's been moving, so I've been noticing that. But it's
All
like,
right, I
you
just
don't
saw
really think
some
about
people
gesticulating
disappear,
until you
so
think you've
hopefully,
paused.
you can still hear me here. But it
Oh,
may
you're
take
back,
a second,
Paul.
but I'm
I
just
hear
gonna
you.
keep talking here. All right, I see you, Andy. Can you hear me okay? You want to give me a thumbs up?
We sure do. Thanks, Paul.
Okay, yeah, all right. So I'm just going to keep talking, and eventually, sorry about that. So, they sometimes would reach out and talk to family members, and kind of get them involved in the process. And because this was a pilot, they couldn't provide this service to all of their clients. And so working with us, we suggested that in order to enable a rigorous evaluation, that they shuffle the days and the shifts in which this service would be offered. And so they agreed to do that. And so that shift shuffling
provided an opportunity. Let me just share my screen once more here. I think you're going to have to give me co-host privileges again here, Andy. I'm going to keep talking, and when that happens, I'll share my screen again so you can see the slides. But So we were able to get some administrative records that kind of cover the set of defendants who went through this process. And then we also, again, did some interviews, prosecutors, some of the bail advocates themselves, various personnel involved in the process. Okay, here we go. I think, let me try this here. All right, great. Thanks for your patience with that. All right. So what did we find? So first of all, when we talked to people, everyone said, well, certainly if this accomplishes nothing else, it's going to enable more people to be released pre-trial. Having that additional information that you can raise in the hearing coming from the bail advocate. And we actually didn't see that, right? So we did the analysis, no statistically significant difference in release rates between those with and without the bail advocate. But what we did see is that there were fairly substantial impacts on some downstream features of the case. So for example, the likelihood that someone would have their bail revoked or forfeited by picking up another charge or failing to appear went down substantially by about 2/3 for those who had access to the bail advocate. People were much less likely to get rearrested, and that's true both if we look during that pre-trial period, and then also if we were to look further out, a year, 18 months, longer after the case was resolved. And again, these differences are fairly substantial, maybe on the order of a 25% reduction. And, whether you think the system is fair or not, right? I think people in general agree that having people not show up again is a good thing. It's good for the client, and it's good from the perspective of prosecutors and other actors. And that's what we see these bail advocates achieving here. We also saw that the cases would resolve in more favorable ways for the client. So, for example, more likely to have the case dropped or to be acquitted in the case. Received more lenient sentences. So probation tails, a big challenge here in Philadelphia, and we saw that that was less likely as a result of having the bail advocate. Another thing that we were able to, and the data, of course, on race is very coarse. For those who've worked with criminal justice data, you know that, but we can at least look at kind of black-white differences. So in Philadelphia, if you were to take a pool of 100 defendants, 59 of those, 59% are going to be Black who begin and get arrested. If we look at those who get detained, right, the proportion goes up to 66%. I think consistent with what we see in many jurisdictions, there's this magnification of racial disparity as we go further on down the process. So based on our experimental estimates, if we were to take that same pool of 59% Black and give them all access to the bail advocate, if we look through it who gets detained, there's no longer an increase in racial disparities. I think this is actually, to my knowledge, the first kind of contemporary example of a pretrial intervention that's been evaluated using an experiment where we have demonstrable, statistically significant reductions in racial disparities from the intervention. Of course, people have talked about, hey, risk assessment tools and other things can accomplish that. Maybe, maybe not. Here we have an experiment that suggests in this context, the intervention would reduce racial disparity. So we tried to understand the mechanisms for this. One is that it seems that one of the things that the bail advocates do is they bring to bear, they provide different information that can help both the prosecutors and the magistrates making decisions about bail to make different decisions. We also think that there was kind of a procedural justice, if you like, impact. If you think about it, the normal process where, you get put in this pretrial detention unit, then you see some videos. Often the audio is very bad. No one has really explained to you exactly what's happening. The person who's on your side, your public defender, probably what they do is tell you to be quiet so that you don't say incriminating stuff. It's not a very kind of customer-friendly process. And so having someone who's actually there and talks with you and hears your side of what happened and explains what's going on, we think kind of improves people's engagement and their sense of procedural justice in a way that has implications for how their cases ultimately resolve. So I want to get to kind of questions and discussion, but let me just talk briefly about, with these 3 studies, what do I view as maybe some of the kind of larger takeaways, both as we think about implementing better public policies related to indigent defense in our communities, and also are there any insights for research? I actually think there's a ton of things that we can draw from these. I'll just focus on 2 particular, I think, kind of big picture insights. First of all, indigent defense, it seems to matter quite a lot, right? Across these studies, we see, it matters in very complicated cases. It matters in the low-level drug cases. It matters at the very beginning of the process. And so, I think the work that folks are doing here to try and better understand that and make that information available to policymakers is super important because, by all accounts, it's clear that this has big implications for how big the system is, how many people go through the system, and the choices we make reflectively or not are going to have significant implications. And one of the things that I hope these studies do is point us to, some particular ways of providing these services that might generate better outcomes. I think another big takeaway is in all of these interventions, if you think about the scale of the kind of resource expenditure on the public defenders, it's pretty small relative to these downstream impacts. We all know what sort of resource challenges indigent defense in general faces. I think a lot of times when we talk with policymakers about this, we kind of frame this in terms of, hey, there's a constitutional obligation, and so we need to provide enough resources to meet that. I think there's actually another very pragmatic argument, even for people who don't necessarily care a lot about the rights of indigent people in the criminal system, right? I think as these studies demonstrate, a lot of times it's really a question of we can invest a little bit now to provide better defense, or we can spend really a lot later. In the case of Pennsylvania, $200 million plus dollars, millions of additional dollars in terms of incarceration. And so, kind of recognizing and being able to demonstrate that feature of our decision-making around indigent defense funding, I think is important. Research-wise, I'll mention three takeaways. We've been very privileged in these studies to have courageous partners, people in the Defender Association and the Bronx Defenders who've been open to research, who've been willing to subject their practices to rigorous outside evaluation. I think in the end, having independent evaluations, I hope, has been valuable for these organizations in terms of making the case for support for expanding what they're doing. But it takes a lot of courage to do that. We researchers we are not always the easiest people to work with. But I think one of the reasons this has been successful is we've been able to have investment and engagement and involvement with people on the ground. I think a second takeaway is for each one of these studies, there were things that were pretty surprising in the results, right? I think that, for the bail advocates, everyone thought, oh, certainly they're going to affect pretrial release. Didn't turn out to be true. I think for public defenders in murder cases, right? One of the things that we find is that essentially one of the ways that the public defenders get better outcomes is because they recognize cases that if they're taken to trial, they're going to lose. And if they don't take them to trial and they kind of leverage their advantage in plea negotiations to get better outcomes for clients. And the private appointed attorneys take those, lose, and their clients get life sentences, right? I don't think people would have necessarily said, oh, hey, this is one of the major ways that public defenders benefit their clients in this context. But it turns out the research reveals that seems to be what's happening. Now, I think the research design and having these causal research designs, I think one of the reasons those are so important is that when we do get these results that might seem counterintuitive, I think it can allow us to have confidence that, yeah, we're really measuring the effects, and it's not just that we got something wrong in terms of the research. And so, that attention to strong research designs, I think, has been really valuable because it creates a space for potential acceptance of results that otherwise we might think, oh, that really be true. I think the other final insight that I'll just conclude with is, all of these projects involve kind of large scale quantitative analyses, data analysis, and then also interviews and qualitative stuff. I don't think any of the studies would have been nearly as effective with only one piece or the other. And so I think there's some real returns to trying to bring together these different approaches. All right, so I am going to stop there. If you're interested in the underlying papers, here's some links, contact info. I'd love to hear people's comments, questions.
Thank you so much, Paul, and really nice job persisting through the technical glitch there. That was almost seamless. This work is so tremendously valuable. The group has got a little bit bigger. So what I like to ask is that if people do have questions, please use the raise hand feature. You'll find it under the reactions button at the bottom of your screen. You ought to be able to raise your hand there. If you, and then I'll call on you to unmute and speak your question. Folks can also, if you choose, you can write a question into the chat box, and I shall be happy to relay that to Paul also. So I know there's an awful lot to absorb there. Certainly, I've got copious notes, and I've got very comfortable with lengthy silences also, so I'm quite happy to wait for the first question to appear. But here it is. Oh, Larry
Yeah,
Jemison would like to
let me just
the
see if I
studies in
can
the chat.
do this right here. We'll see how well this works. But all right, so those didn't provide the links, but you've got at least the names of the studies there.
I can throw a link in the chat from the Penn page.
All right, thanks.
Thank you, Malia. Lisa, go ahead.
Hi, thanks, Andy, and thank you, Paul. That was really a wonderful presentation. I really appreciate your research. I hope I asked this question in an eloquent way because my mind is kind of going a little bit in a circle, but I think advocates do wonderful things for criminal cases and for people who are facing criminal charges, and I really support advocates. But I'm wondering if your research, and maybe not this particular study, but maybe a different one or other studies, if they looked at actually having a lawyer do that interview, increase those pretrial release decisions, and that advocates could do the same advantages that they found in your study, but at a later point. I'm not sure if that question completely makes sense. And
no,
also,
I think the question makes sense. You know, there has been, I think, some interesting work that looks at having a lawyer versus no lawyer, right? You know, so the work by, Sean Bushway, some interesting experiments in the 80s looking at that. And clearly that, you know, there's a big benefit to having an attorney at first appearance. Now that's a little different, I think, from your question, right? Which is, would it have been even better that if they had, you know, kind of trained legal personnel doing the interviews? I think the answer is we don't know from the Philadelphia context what's the trade-off. I mean, it's interesting when we did our interviews, right? One of the things that came out is, this was kind of consistent with both kind of the attorneys, you know, that we talked to as well as the bail advocates, is they said, you know, it turns out one of the things that's like a very important skill here is just like emotional de-escalation for people who have just gone through this experience of being arrested. And, you know, hey, with our background in kind of social work, we get a lot of training to do that sort of stuff. And the attorneys, on the other hand, you know, they're thinking about legal arguments and other things. So yeah, I don't think we know the answer. I think it's a great question. I think there are some reasons to think that there may be some advantages to the skill set. And I think there's certainly been some kind of interesting emergent work. There's, you know, for some of you who are, you know, familiar with Partners for Justice and their effort to try and bring kind of advocates to more public defender offices who can engage at kind of later stages in the process. I think that's kind of a really interesting, possibility, and one where, you know, I think we still have more to learn.
thank you.
Thank you, Lisa. Sean Bushway is up next.
Sorry, I'm not in a position where I can give a video, but so to follow up on that, Samina Anwar and myself and John Enberg have a working paper that will be released at any moment doing an experiment in Allegheny County, which is in Pennsylvania, obviously, but not the same context because the prosecutors are not at the hearings, in which the lawyers did talk to the people beforehand. And what was interesting there, I don't know what the context in which the advocates in the Philly got to talk to the lawyers, but in our cases, they were often talking through the jail doors, crouching down in the gaps and things like that. So it wasn't exactly the most conducive meetings, but that's where all the action was, because the hearing itself, there was very little exchange of information. And in fact, the decision was already made prior to the hearing. So if you didn't get the information to the magistrate ahead of time, it was over. And so we found that, you know, that meeting with the lawyer was important. So, you know, I don't know if it necessarily tells you that having the advocate wouldn't have been, But that was crucial in our case, even though the meeting itself didn't seem to be that helpful. So I'll let Samina talk about the paper if she wants to talk about it in more detail. But we had a similar situation where we had not enough lawyers to cover all the shifts, so we did much the same type of random assignment that Paul did. And so I think it's hopeful that that kind of approach is possible.
Yeah, I mean, that's really interesting, Sean, and I'm looking forward to reading more about that. Yeah, I mean, it is interesting, right? So in this setting, the bail advocates would, kind of meet with people there in the unit, and they had a space. The way they actually had kind of an electronic note-taking system where they would, kind of bring notes together, and then that would be accessed by the attorneys who were staffing the hearings. And so that's how the information was transmitted over. So one of the things that we do actually do is we have like timestamps for when the arraignments occur, and we show that having a bail advocate actually increases the amount of time that the hearing goes, right? And so I think that's some indication that indeed there's an information transmission mechanism that involves, that, once you have more to say about the person because you've actually talked with them and know something about their circumstances, that maybe allows you to raise some different arguments than you might otherwise. But I think there's some data kind of consistent in our setting that that's one of the mechanisms where that happened.
Thank you, Sean and Paul. Shamina, I know you were called upon there. Do you have anything to add?
Oh, no, I think Sean did a great job summarizing. I was just going to say, I think what was interesting in our case, though, is that we found somewhat different results than what Paul was getting. So his was looking at the bail advocate, and then we were just looking at the impact of just having the public defender. And we did see, significant decreases in pretrial detention, but then we also did see, a slight increase in rearrests. And in particular, what we found is that was mainly for like theft charges and things like that. So again, and I think Paul, you had kind of noted this, like with the bail advocates, some of the services they gave may have also helped, I don't know, with, rearrest down the line or things like that. But, definitely one of the things that we were wondering is right now there's no like social workers, at these bail hearings here in Pittsburgh, but, potentially pairing something like that would be useful to evaluate, I think, as well.
Yeah, I mean, that does sound interesting. And you're right that one, so the bail advocates is like de-escalation, information collection, but also one way that you can make a more effective argument is, hey, this person has somewhere to go if you release them. Hey, we've got a slot in the drug treatment program that we could send them to, right away. And so they would certainly, try and make those arrangements and make the connections as their time allowed. And so, I do think that, and of course, there's all sorts of challenges, but that was, I think, kind of a real, like, intentional part of what the bail advocates did, was thinking about what sort of connections to services and other things might position a client to make the best case for, kind of pretrial release, that, they're going to be able to show up, that there aren't going to be issues.
So I encourage people to keep raising their hands as and when they have questions. Paul, I just had one that I'll interject. I just wonder generally about your method. I'm particularly always appreciative of your last comment there about how the quantitative and the qualitative are always present in your studies. And the way I often perceive it is that quantitatively you establish some difference between two categories of cases or something like that. And then that qualitatively you go in usually on the back end to try and sort of unpack what might be going on. And so the way I perceive it is that you sort of first establish that there's a difference through some really sophisticated statistics, and then kind of try and figure out what the story is, what the mechanisms are. Is it the case that that's always the kind of dichotomy, that you're sort of left with finding a quantifiable difference and then having to dig in qualitatively? Or is there a sort of like next stage of this research where you start to statistically vary the things that you're picking up on the qualitative side? When you talk about things like humanizing the client or something like that, conceivably one could perhaps vary that or something like that. I don't know if that's I mean, I'm not really intending to be provocative, but I am a little bit at a loss to wonder if it's even possible to imagine going in that direction. Or are you just always stuck in this situation where your statistics are on administrative data matters, which are relatively blunt, and then the storytelling is just inevitably having to go beyond where the statistics can go?
Yeah, I guess, and that's a great point. And I think that I think your characterization, I'll say that in terms of actually doing the research, we're usually running both tracks simultaneously. And certainly, when we interview people, we may not know, or even if we do know, we don't tell people what the results are because we don't want to, kind of taint their impressions of how they describe their programs. Sometimes I think it can be kind of iterative, right? So, if we learn that, hey, one of the things that people are telling us is that the judges are getting better information, is there a way we can go back to the data and actually kind of test that, demonstrate? So one of the analyses I didn't talk about, but that we do in bail advocates, is we know who the magistrates are. And so we actually go back when we hear that. In fact, one of our interviewees said Magistrate X is one who we think has been very responsive. So we actually went back to the data, and sure enough, if you allow magistrate specific responses, Magistrate X turns out to be more responsive, just like they said. So sometimes there can be some interactions. I do think your larger point that some of these ideas about the mechanisms, I think the next stage is, can we test those? Can we measure them? In some cases, maybe, right? One of the things I'm hoping to do 5 years down the line, maybe sooner, when we've accumulated some cases, I mentioned, right? One of the things that happened with murder cases in Philadelphia is, we started staffing the private appointed counsel in pairs. We quadrupled the compensation that they received. So we've actually changed a bunch of the features that we identified as being potentially problematic. So are we seeing differences in outcomes as a result of that? I think we could use kind of a similar research design and maybe look at that in the future. And that could be pretty useful and interesting, I think.
Thank you. That's really thought-provoking. I see Jenny Roberts has her hand up.
Hey, thanks, Andy, and I hope you guys can hear me. I'm in a car, not driving. Can you hear me, Andy? Can you
yeah.
Okay, great. Hey, Paul, thank you. So maybe you can reshare the slide for the Indiana study, because I may have been reading it wrong, but what I thought I heard you say was that the downstream outcomes for actual detention didn't change, but the racial makeup of those detained did. Is that correct?
Yes, that's correct. So the average detention rates across the entire population were not measurably different. But we do see that like one way that you can think about it is the impact of the bail advocates seems to be a little bit bigger for Black defendants. And so, yeah, we kind of see.
Well, I guess that was my question. Is that the way it's going? Is it helping Black defendants? Is it helping Black defendants and hurting non-Black defendants? Is there any way to know what's going on there?
Yeah, I mean, it's, and so, let's look at the picture, right? So, these numbers are actually accurate. So you kind of have, kind of one additional white defendant, if you will, and, kind of 3 fewer Black defendants based upon our estimates. So
everyone's getting a benefit.
Yeah, I mean, it's, I think, yeah, and I think you have to be a little bit careful in thinking about how one interprets that. I mean, it's like the way I describe it, and to me, I think the most productive way is just thinking about the disparity in general. So, for example, if, you think about the work of, Jennifer Eberhard and others, right? If so, what's going on here is that there's some sort of implicit bias. And so what happens is that the bail advocate slows down the decision-making process in a way that allows us to overcome that implicit bias in some way. I think that would be kind of consistent with the sort of story that we see here, and kind of a narrowing of racial disparities. Like, is that helping or hurting? I mean, I I think it's making it more fair, right, in terms of removing that kind of heuristic, which affects one particular group. But yeah, it's but it's
thank
an
you. That was
interesting
my next
question. Yeah.
Thanks a lot.
Thank you, Jenny. Anybody else? We have some comments in the chat. Maria observing perfectly correctly that you deserve kudos, Paul, for stitching these together. All are important individually and even more so considered together. Bob Borukowitz noted that the Maryland study on lawyers at first appearance. I think this was in relation to the earlier note that you made,
Yep.
Paul, about the Colbert Colbert et al. Study also from Baltimore.
Yeah. So I think that this is actually an area where, at this point, again, we've got a set of studies in the 80s. We have that work. We have this. We have Sean's new work in addition to the previous stuff. So at this point, I feel like this is an area where the evidence base is looking better and better. And in general, right, as we know, one of the challenges with criminal justice policy is kind of non-replicability. You find this kind of promising finding, and then when you replicate it in different contexts, we're kind of not seeing impacts. But this is actually an area where I think somewhat encouragingly, I think, when we use these high quality randomized research designs, it suggests that, yeah, indigent defense can be really beneficial here at these early stages. And you have a cluster from a variety of different contexts, time periods, etc.
We really do. And we're also on the cusp of being able to integrate the kind of stories that I think Sean was alluding to. And I see your hand up again, Sean, because we do have this cluster of studies. They do, of course, show, the Baltimore study showed enormous effect sizes. And, the study back in the 80s, I don't think quite did. And so stories like where the interaction between the client and the defense attorney is happening and how the information is conveyed to the judge, it seems to me might be where this goes if you have these findings that show broad consensus, but difference in effect sizes, or maybe not so much consensus. But Sean, I should actually defer to you.
Yeah, first of all, it's technically Samina's study, not mine. I'm a co-author, but the one in Pittsburgh. And then I was going to say a little bit about your qualitative study, but I'm happy to briefly mention the Maryland thing. Is we didn't find quite the division that you mentioned, Andy, in terms of the quantitative sets up the results and the qualitative does the mechanism. Because without the qualitative work that Samina just really did extensive work in trying to understand the process, we couldn't even done the qualitative. When you really got to dig in and understand what's going on before you can even do the quantitative work. And it's qualitative work, right? We had people in the courtrooms. We were extensively interviewing the judges and the magistrates and the lawyers to try to understand the processes so that we could even do the random assignment. So there's a ton of what you would call qualitative work that goes into setting up the quantitative. And if you don't do that, you're going to be toast, because it's complicated in these systems. And so you don't even have a chance of understanding the data without that. And I think Samina did a fantastic job of that. On the Maryland study, that was the only attempt that I know of where the goal was to sort of randomly assign people kind of at the individual level, where you sort of either did or didn't get a lawyer. And it wasn't based on shifts and things. And one of the problems we had was that the Doug eventually broke the random assignment because he felt bad for some of the defendants because he knew he could help them. And that undercut the value of the study. Now, I think in the end, unfortunately, Doug, bless his heart, was afraid we'd be mad, so he didn't tell us which ones he broke. And if he had done it, we could have fixed it. I think it's really hard when you do the individual level assignments, because the lawyer can definitely see situations where they could help them, and it's really hard to say no, I'm not going to help you. Whereas the shift assignments really does take that problem away. And as you'll see, if you look at our working paper, we had really good adherence to the design. And Paul, you can speak to your paper, but my understanding is, and from what I remember from reading your paper, you also had very good adherence. And so that really improves on the power and on the assignment. So while it's not technically a true random assignment where you're assigning everybody a lawyer or not in any given case, I think it's a really powerful design that gets away from some of the ethical problems you face when you do or don't give someone a lawyer on an individual basis.
Yeah, no, I think that's a great point. And you know, again, right, you know, I think the Defender Association in this letter, you know, they already knew it was a pilot, right? They didn't have the resources to serve all clients. And so, you know, you can either deploy that in a way that's going to allow you at the end to know for sure what the effect was, or you can use some other way of deciding which shifts to do that don't give you that benefit. You know, again, we were fortunate to have a courageous partner that was willing to do this to facilitate evaluation, but that basic problem of not being able to extend to all clients, you know, would have existed in either case. Janet, it looks like you have a question.
Yes, thanks, Paul. It's always wonderful to hear your work and to see everybody see how IDRA is so lively and engaged. So picking up on the comment about being toast without the pre-work, I just want to put in my pitch for you wonderful folks that are doing this work to, if you're not already doing it, to think about figuring out your research questions and your approaches to research and your frameworks, your design by doing participatory work, including with the organizations, the community groups, and the social movements that are out there in the trenches on this stuff. And I'm thinking especially about the participatory defense movement and their latest iteration of their interventions in the pretrial setting with their court doing and first 24 enterprises. They're generating some interesting data. They're tiny sets, and I know that that can be tough for you big data folks to be engaged with, but I truly believe that in order to achieve sustainable, productive change, we who have the privilege of doing research need to connect with those folks. So thanks, great stuff. Looking forward to hearing more.
Yeah, thanks.
Thank you, Janet. And Paul, I want to give you the closing remarks because we're just on the hour, but thank you so much. I want to let you respond.
Oh yeah, no, I mean, I plus one for that. You know, we've you know, collaborated some with participatory, you know, defense groups, and I do think that that's kind of an like an important emerging phenomenon that merits more study. Yeah, I just want to say thanks, thanks to everyone for your comments. And you know, one of the things I'm excited about is we've heard references to a few other studies in the pipeline on these topics. And so we're going to learn even more. Thanks, Andy, for facilitating it. I hope everyone enjoys the rest of their Friday. Have a great weekend.
Thank you so much. Thank you, everybody. We'll see you next time.